Well, welcome to Judicial Ways of Working, the podcast series produced by the Institute of Advanced Legal Studies at the University of London. My name is Carl Stychin, and I'm the director of the Institute. This series explores how members of the judiciary are working during the global pandemic crisis. I'm delighted to welcome Mr. Justice Lorne Sossin to today's podcast. Justice Sossin was appointed to the Ontario Superior Court of Justice in December 2018. Prior to his appointment, he served as professor and dean at Osgoode Hall Law School at York University in Toronto. Previously, Justice Sossin was a professor at the Faculty of Law, University of Toronto. While there, he was an associate dean and served as the inaugural director of the University of Toronto Centre for the Legal Profession. His teaching and research interests have spanned administrative and constitutional law, civil litigation, legal ethics, and the judicial process. He holds doctorates from the University of Toronto in political science and from Columbia University School of Law in New York City in law. Justice Sossin has published numerous books, journal articles, reviews, and essays on administrative justice, judicial review, and access to justice. Lorne, welcome to the podcast.
Thank you for having me, Carl, and again, kudos to the Institute for putting this series on. I'm looking forward to checking out all the others and very privileged to be a part of it to share my perspective.
Well, you're very welcome, and that's very gracious of you. Perhaps a difficult question to start off with, but could you describe for our viewers your everyday professional life as a judge to us as it was before the pandemic? So what was life like before?
So it does seem like the mists of time, but of course we're talking here just about in Toronto and in the Ontario court system that I'm a part of prior to March 15th or so. And I should add that, I'm speaking about my experiences, and they're very much informed by life in the main courthouse here in Toronto. And this will be different in the various regions. The region of Northern Ontario court district is about the size of France. So these are large areas of territory, sometimes densely populated and a very diverse context, such as downtown Toronto, where I sit, but other demographics and dynamics will inform other courts in Ontario and throughout Canada. And of course, I can share what I understand to be happening in some of those places, but I'm really going to focus on my experience. And my experience, and I think this won't be uncommon in the Canadian context, was a very physical presence-oriented one. That is to say, occasional teleconferences on some matters typically held, again, in courthouse facilities, but overwhelmingly in person, where the day would start at about 9:30 with some chambers appointments, and then a motion or trial that would begin at 10. And go until late afternoon, anywhere between 4:30, 5:30 to 6 in the late afternoon would be typical. And again, with lots of collegial touch points, often having lunch together with other judicial colleagues, very busy hallways with lots of discussions going on of ongoing matters, lots of judicial conferences and meetings that would break up the sitting days. So it was a before time, as many are now calling it, very much built around those kinds of interactions in person, and indeed sometimes inefficiently so. You'd have on a busy civil motions day, for example, lawyers and parties coming that might represent 6 or 7 matters that they'll need to speak to for a half hour, an hour, maybe a couple of hours. But everyone would come at 10 and then be given a slot, and often waiting around for several hours to be heard. So you can tell this is going to be a precursor to some of the issues that are now with the advent of a much more technology-focused adjudication system going to be changed in not altogether negative ways, or ways that really won't show us a better way of running a justice system, at least based on my experience, than I was, I was part of before. But we'll get to that, I know, in a part of this discussion to come.
Great. Well, you have foreshadowed brilliantly the sorts of issues that we're interested in this podcast series. And you did mention that there was some role for technology in the before the period. Can you elaborate a little bit on the extent to which judicial working was technology enabled?
I will, but I actually want to mention, because I know this is a dynamic in many of the systems where you're going to have people speaking about, and of course is a big part in the UK of the justice system, and that's the tribunal world. And it's a world that, as a part-time member, I came from before my appointment on two large health boards here in Ontario. And I mention it because those boards had already moved to completely paperless submissions and records. So all the records of investigation submissions would all come on encrypted cloud-based online platforms. And there was a range of choices between teleconference, electronic hearings already in that tribunal context. And in fact, Canada has one of the world's first completely online statutory tribunals in British Columbia, the Civil Resolution Tribunal, dealing with a host of small claims, condominium disputes, auto insurance, things like that. So when I was appointed, coming from that kind of adjudicative background, I was struck by how little there was, I should say, in the way of technology-supported adjudication. And in fact, a couple of divisions of the court were receiving submissions on a USB stick, often in addition to, rather than instead of, Surlox-bound paper copies. But for the most part, it was a very paper-intensive process. As I said, the occasional teleconference would be scheduled mainly for matters like scheduling, case management, things of that nature, and very, again, rarely for anything that would have a substantive outcome. No online use of any of the video conferencing platforms, apart again from some judicial education. Some training might involve that, but certainly not the adjudicative side. So, and there had been talks of modernizing. There had been a push to bring some technological assistance to the process, mainly again around e-filing and a paperless system. But all that was moving again at a glacial pace from my experience, and there are a host of reasons why that will be, I'm sure, familiar to many of the people listening to this. The varying responsibilities between the court and the Ministry of Justice over staffing, resourcing, policy guidelines, the different experiences in regions and different courthouses, the preferences of judges, counsel, the differing perspectives of the profession and other stakeholders on this, and the different level of resourcing and sophistication and eagerness of the public. So it was a solution again that was already being called for in some quarters, but there were enough of these constituencies that had concerns or legitimate worries about privacy, about encryption, about data, about public access, and all of it just meant that the complexities were grinding this process to a much slower pace than it might have otherwise taken. So, as I know, many other jurisdictions had moved further ahead than we were at, but I think this was certainly a typical representative judicial system where there were some early adopters, some resistors, but generally a lack of systemic movement to embrace this kind of technology prior to the pandemic.
Well, that naturally leads into the question, how has work changed as a result of the pandemic? And given where the courts were, how has that been managed?
Well, again, different courts in Canada have approached this in different ways, and even different courts in Ontario. And again, without needing to go too far into the constitutional eccentricities that give us the court system we have, there is a federal court system in Canada that operates throughout the country in areas like immigration, refugee, national security, and patents, trademarks, and a range of areas that are federal responsibilities. There's a superior court in every province, and as well a lower court, often referred to here as a provincial court, and these will hear different kinds of matters. A provincial court will hear less serious criminal offenses. The superior court will have trials on more serious criminal offenses, and again, differing jurisdictions in family. And of course, then appellate courts on top of all that. So courts are moving in different ways, but it's fair to say that the experience I've had and our court has had is a move to only hear urgent matters. So that may be injunctions on the civil front and child protection matters on the family front, bail reviews on the criminal front, but it's still a drop in the bucket of the normal course caseload, I should say, of the courts. And to do all of that hearing remotely for the most part. There's still in the provincial court system I mentioned, some in-person matters that meet the urgency threshold. But for the Superior Court, there hasn't been the in-person adjudication. So it's all moved remotely, mostly teleconference in the criminal law area, and family's been a hybrid, mostly a video conference and teleconference as well on the civil side. So it's been a patchwork quilt operation, again, with not enough phone lines, not enough established bandwidth. Not everyone has the connections to Zoom or other platforms that are being adopted, but it is happening, and it's happening with again the participation of the ministry, court staff, the profession. The Ontario Bar Association has lent virtual courtrooms on its Zoom account, for example, and of course many others who've had to work in some unprecedented terrain as counsel or self-represented parties to navigate this new normal.
Right. Well, and how are you managing this new reality of judging at a distance? What are there aspects that you find particularly challenging?
Well, I think as someone who is a bit more both of a generation and coming from academic life, of a culture that has its own issues in terms of modernization, but was certainly more accustomed to video conferencing, more accustomed to less formality than some others. So I've actually found it equal measures of frustrating and liberating. Liberating again because there can be this much more efficient use of time. People aren't waiting around in the way they might have. You tend not to take quite as many issues on because counsel and parties are trying to resolve what they can so as to fit within this rubric of urgency that is the justification for all the proceedings happening now. And of course, there's typically these are matters where there is a significant problem, an urgent problem to be solved. And so that, of course, provides a real sense of making a positive contribution by participating. So those are the positives. The frustrating part, of course, is the limitations of the technology, everything from people dropping off calls or freezing mid-sentence, talking over each other, not being used to these protocols, some dilemmas about how to provide access to the parties, but also to the media and the public to preserve and promote an open courts principle. And again, it's a trade-off. In some areas, we've had webcasts of divisional court judicial reviews that 500-600 people have tuned in to see, when a normal courtroom would have accommodated 20, and no live stream provided in the normal course. So with every one step forward, there appears to be a step sideways, and again, sometimes a step backwards. The bail review experience, which I don't do in my current area of sitting, but I understand from others who've been reporting this to the media, can be quite challenging when you can't see the individual counsel, and the individual can't just have a quiet moment to chat in the midst of the proceedings as you would in an in-person context. And those are, again, limitations both of the technology and the nature of it being remote, and again, other accessibility and accommodation challenges depending on the language abilities and access to the tech and resources of different parties, and whether they have counsel or not. So again, there's not a one-size-fits-all experience, but so far I found it working reasonably well, certainly well worth the investment of time and energy to keep these areas of the court's work going, and lots of demand to expand this, lots of demand, again, for those matters not quite fitting under urgency, but for the peoples whose lives are involved, disputes that have often been going on already for a very long time, and in some cases, again, with people's lives on hold awaiting the outcome. I'd never want to suggest that any aspect of the court's operations is expendable or can just be delayed without there being a real cost. So that weighs on all of us as well.
Great. Well, that leads very well into another area that I'd be interested in exploring with you. It's an area that formed part of your research agenda as an academic, and I know is one that's still of great interest to you, and that concerns access to justice. And do you have concerns that there are access to justice issues that will be exacerbated by the changed ways of working, and by contrast, are there some aspects that will be alleviated?
No, I think there's been a theme of that balance already in our discussion, and I certainly see it here as well. The benefits, I think, especially for people who don't live in and around the area of a courthouse, who find that ability to get away and participate can be challenging. Those are some modest upsides, I'd say, for a range of people, but there are real barriers that this creates for a range of people, and it's both barriers, again, typical to the justice system, with the variations of legal aid assistance and pro bono assistance, and the very large number of litigants who simply can't get access to the assistance they need, I think is again something that becomes a more stark barrier in this kind of environment, where there are new regulations, new definitions of urgency or of how to access the registry and other court systems that put a premium, again, on the assistance that counsel offer, and therefore create more barriers to people navigating this on their own, from their home, often with limited access to the necessary technology and necessary strategies to navigate all this. So not to mention, again, the matters that do get delayed, put off, are going to overwhelmingly be matters where their concerns may be at stake. And for example, small claims court here in Ontario has been closed for a significant period of time and doesn't fit within the other areas where there are urgent matters going forward. So all of that suggests to me a real access problem, and again, just revealing things like the digital divide, revealing things like how difficult the court system is to navigate at the best of times. So like in other areas, whether healthcare, long-term care, prisons we've been hearing about, it's not so much that the pandemic is causing these challenges, but simply, as you said, exacerbating or revealing in a more salient or stark way some challenges that have long existed. But I am a more glass half full type person who again sees great potential. And I mentioned the Civil Resolution Tribunal in BC. It hasn't missed a beat and is in fact gaining new users who are learning that these are the kinds of aspects of the justice system that haven't been affected in the way others have, because they were designed to be virtual platforms, open 24/7, with very easy to use, well-designed interfaces, again, with a user-centered perspective at their heart, very much in contrast to the evolution, design might be too generous a term for it, of most of our court systems that do critically important work, but have evolved in a way that just is not built to be nimble, responsive, adaptive in the way that we're seeing the need for at the moment.
Right. Well, it seems clear, and we certainly get told it frequently by politicians and healthcare experts, that this is not a case of going from a pandemic switched back to the old normal, that there will be a new normal that will emerge. Do you think that, and it sounds like you clearly do, think there are lessons that we can learn from this time as to how we resolve disputes as we move into that new normal?
Absolutely, and again, I'm speaking from my own experience rather than court policy on these things. Though, although our Chief Justice of the court I'm a part of, the Superior Court of Justice in Ontario, has already said the clock is not going to turn back on many of the. I hesitate to call something like filing materials online as an innovation, because it's certainly been clearly something we could have been doing and other jurisdictions are doing and have been doing for a while. But those kinds of things, I can't imagine why we would go back to lots of Surlox bound materials rather than the online materials. And we had scheduling courts again, as I was mentioning, where many parties would sit around waiting for their turn to do something that would be an extremely easy piece of the puzzle online from the comfort of their office, where they might need to spend 10 minutes on this rather than take 2 hours. I can't speak to whether scheduling courts will make a comeback, but I know the overwhelming sense is that this is a better aspect of the new normal, to be able to deal with those sorts of matters, either in teleconference or online, or even in writing if it's not contentious. So we're seeing a lot of that. We're seeing some interesting innovations that I'm not sure will stay, but might. For example, the provision to witness affidavits, have affidavits sworn with a video presence of counsel rather than physical presence, or of a notary to do so. So those kinds of things that, again, can be real barriers of entry for parties that need to find a notary, need to get these documents sworn. If it's just a telephone call or a video chat, a way to do that, those are things that could be quite meaningful enhancements. It's like I often found this in studies of disability rights and access, that there are very complicated pieces to making certain parts of our society fully accessible to people of a range of needs. But it turns out that you'd achieve 70% of what's necessary if you just didn't have a step leading up to a front door. If you just had that curb, one of the easiest things to change, you'd have a huge impact. And I find, these low-hanging fruit issues are the same in the court system, that some problems are going to be knotty, nettlesome, ones that knotty in the KNOTTY sense, that are going to take a lot of effort to resolve. But there's a whole bunch of things that are easy, simple, sensible changes, but again, require buy-in and require justification, and we'll have worries about consent capacity, other aspects that need to be dealt with, privacy, data protection. And I don't diminish any of those complexities and worries, but again, I think there's a lot of these things that once we see the benefits of the change and have the empirical data that can be part of studying those risks and how significant they are, I think we will see a lot of these steps taken to adapt to the pandemic as additional tools in the justice system going forward, if not, again, a new normal that will be here to stay.
Well, you've just spoken about the impact on the courts, on the resolution of disputes. I'm also wondering about whether there will be a permanent impact on members of the judiciary, on how, on the skills they use, how they work. Will you and your colleagues be changed by this in interesting ways?
I think absolutely yes would be my response. I mean, it's a very interesting thing as well to probe what's significant about the system and the trappings of it in particular, that this response to COVID-19 is raising. How important is that courthouse, that, whose architecture, whose seals and signifiers are so central to our thinking and images of the justice system? Is it about those bricks, mortars, and stones and facades, or is it about the people, court staff, counsel, judges, parties who are really the justice system? And that's a movable feast, as it were, whether that's online and whether people are in robes or regalia or not. Does that matter, and what matters about it? And I think there are some aspects that are central to how judges view their role and what differentiates it from roles that they've played prior to their appointment that are challenged by everyone, having the experience of being at home. And of course, the life the judges lead will be a diverse one. Some are homeschooling children in the midst of working on reserves and injunctive relief. Others are reconfiguring basements and other settings to be their virtual workspaces with Zoom backgrounds of the courthouse, and others are really struggling, I think, to create that sense of a different place of mind when they're performing these roles. And again, some are in very different life circumstances in terms of their other duties, worries, concerns, level of productivity, care responsibilities. So that sense of their lives, I think, and melding together with their professional and public commitments is something that's both new and I think will have a lasting impact. That sense of filtering what's important and meaningful about what we do versus what is expendable or non-essential, to use one of the key terms of the era, is something I think that every judge will be experiencing and will be processing in real time as this unfolds.
Well, that leads really nicely into my my last question. Clearly, many people are finding it a challenge to be at home working. As you've said, people are in a wide array of different situations, and it does expose inequalities enormously in many different ways. But maybe a cheeky question to end on. Have you got any advice, any words of wisdom for those who are working remotely these days?
Yeah, and look, this is a moment where there's a certain peril to give advice because people are so differently situated. But the advice of more universal application that I'm trying to take and circulates from different sources in different contexts, but resonates for me at this time is that advice to really focus on kindness and compassion and having a sense of more understanding for the challenges around us. So things that might strike us as not the right thing to say or not the right thing to do, or not reacting the way you should to something, or if it's in the context of adjudication, not being as focused or as effective as someone might normally be. Finding again that space to put things in context in this moment, and to do so with that kindness and compassion piece uppermost. And again, I think in the way that this has been revealing, and we've talked about that in different settings, it's also revealed, I think, the best and the worst of us. And happily, at least in the circles I've been fortunate enough to move in, I've seen more people for whom this has brought out the best than the opposite. But I think we need to appreciate those kind of underlying stresses and challenges, anxieties and worries that inform sometimes what we see in that tip of the iceberg sense. So my advice is to find that inner focus on kindness and compassion, and really try to live that in the professional worlds we work in addition to the personal connections and life, in the rest of the apartment or the house, apart from the screen or the phone that you're working on, and of course. Appreciate the economic challenges we haven't talked as much about, but the huge pressures that puts on people, on relationships, on families, on workplaces for lawyers, paralegals, others involved in the system, worries about safety and security that court staff and public servants will always have top of mind, and those who manage, supervise, and develop policies for them. So that sense of understanding the challenges everyone is trying to sort out, and that most of the time, most of the people are doing their best. Sounds like the simplest of all pieces of advice, but it's surprisingly elusive sometimes in the moment when you're caught up in something, to remember that. So I try to remind myself of it as often as I can, and hopefully it's something we get better at as this continues and maybe with us for a while.
Well, wise words. And Mr. Justice Sossin, thank you very much for joining us remotely at the Institute of Advanced Legal Studies. And on behalf of our audience and myself, let me wish you all the best with your judicial ways of working. Thank you very much.
Thank you very much, Carl, for the chance to participate in this and for all the terrific work you and the Institute are doing to make sure we take from this experience as much as we can moving forward.
Thank you.